Appeal, part heard in the matter of the Queen on the application of a Salvato and the Secretary of State for Work and Pensions.
Yes, Mr.
My Lord, you asked if we could provide a note to you on the operation of the regulations. And in respect of the assessment periods, you should have the note that was in fact provided to the High Court after the hearing.
That's very helpful. You say in respect of, I'm sure this is what we wanted, but it is focused on the particular point we asked about.
Well, if you look, my Lord, it sets out the regulations that we've already been through. It sets out at paragraph 3 the effect of these provisions. The regulations permit only claims for relevant childcare, provided so that a claimant can take up paid work or continue in paid work, C33(1)(b), that's attributable to that assessment period, defined in 34A, that has been paid for, 31ZA and 34A. Then at 4, these constitute the separate conditions that need to be satisfied. Where childcare is split over 2 assessment periods, the calculations are the ones that are used and set out in the regulation at 34A2, which we've seen, and the point there being that it might take several assessment periods in order for the claimant to recoup the full amount that they have paid in the first assessment period. And that's the point that I made yesterday on behalf of the Secretary of State. If you pay an amount in January that's also to cover childcare costs in February, you will get paid the first tranche for your costs in January and February. You will get paid for the second tranche that takes place in February in March.
Okay, I'm sure that's right. It still doesn't leap from the page, but I expect when we look at it carefully, it'll become clear. But so you say the effect is that if you are made to pay for 3 months in advance, you will only get it back 1, 2, 3.
Yes, but my Lord, also at first instance, the High Court at paragraph 24 agreed with that interpretation of the regulations.
Well, I dare say, but that doesn't necessarily mean it's right.
Yes, well, that hasn't been challenged.
No, but all I'm having, sorry, I came out shirtier than I meant. It was because I didn't understand it, not because I thought it was an issue. Okay, I'm sure, thank you.
Milo, can I say there's also quite an important fairness aspect to all of this as well? Can I just make this crystal clear?
Do in a minute, but can I just be clear about this? Remember, the point that troubled us yesterday was what happens in circumstances where you have paid and been repaid and then haven't taken the up the childcare. Is it the consequences of what you have explained here that could never happen?
So if you've paid for your childcare and you don't take it up, then we say that that's caught by the regulations because the childcare has to have been provided.
No, but what?
So if you reported that you hadn't had the childcare, that money would be recouped under the general provision that's available to the Secretary of State to take back monies which have been overpaid.
So there is no specific provision that says, A, that you've got to report the fact that you haven't had childcare, and B, no specific provision requiring repayment. You say it's under a general power to get back the money.
Have you referred to that in this note?
It's section 71ZB.
Is that in this note? Is that in this note?
Sorry, that's not in this
Well,
note.
this was what we wanted to ask. This is exactly what we were asking about.
Well,
Sorry, so it's section 71ZB. But I'm sorry, Mr. Cobb, you're very familiar with this, but were not. I thought the effect of your explanation was you could never have a situation in which, because in the case where you pay in advance, you only ever actually get a payment of the childcare element after it has been taken up.
Yes.
After the care has been provided, that the recoupment situation, the problem that was causing us concern yesterday could never arise, because if little Jimmy gets measles in month 2 and you've paid 3 months up front, you can't claim for that.
Yes, precisely.
So the recruitment isn't relevant.
Yes, I agree. That's right.
Okay.
I think I was thinking about a much shorter period of time within which, if you paid out. So I had that in mind.
But are there any circumstances in which
There must be.
you could have received the childcare element for services that have not been provided?
No, that's what we're saying. That can't happen. You have to have had.
But were you saying you were thinking of a shorter period? It couldn't happen even in a shorter period, could
I
it?
think what I had in mind is if your child had a couple of days off within an assessment period, then technically speaking, and you had paid in advance, I think that's what I had in mind. But I agree with the way that your lordship has put it, that would never arise. So if you have paid, in that example, if you have paid in January for childcare that's going to take place in February and you don't take it up, then it's quite right, you would never get that paid.
Okay, thank you.
Provided, of course, that you tell the Secretary of State that you haven't taken it up.
Yes, you still have to report in each assessment period that you have taken up.
Yes, it would be that way round. It's not so much a question, as I understand it, the report doesn't say, there'll never be an occasion for the report to say, I didn't take it up, because the report is only what you did take up.
Yes, I'm grateful to Ms. Kennedy. You do, so you still have to report in each assessment period. So even if you've paid in advance, you still have to adhere to the reporting condition in each assessment period.
Well, have we been shown? I don't think we have. We been shown what the report looks like. Have I not got this right? Each month, you make a claim, or you say in your. Is the word ledger correct? There's an online page.
Yes.
What is the word? Journal. Journal. Sorry. You say in your journal what payments you have made.
Yes.
And unless that's questioned, you will receive 7 days later those payments. But those payments have to say, I have made this payment, and they also have to say, for childcare received.
Yes, that's the condition, that's what you have paid.
So you shouldn't ever be saying, I have made a payment of £100, but actually
I didn't take the child.
I only took up £50. You should just say, I'm claiming £50.
Yes. I'm claiming for this amount of childcare in that assessment.
Actually taken.
Yes.
Well, I see heads being taken on the other side. So I don't think we've quite got to the bottom of this. It's not useful to explore it in this way. I'm not totally convinced it really matters at the end of the day for the points of principle we have to decide. But you never know until you've understood it properly. Can I ask the juniors to have another go over lunch to make sure we understand in words of one syllable exactly what happens? And if there is in the evidence a screen print or something of what the journal entry looks like, what the journal entry ought to look like, I think that would help us.
Okay.
Right.
But my lord, can I just return to the fairness point and where these assessment periods actually go to fairness as well? You saw that in Regulation 36 there's a cap on the amount of childcare that can be paid in an assessment period. So for one child it's £646. So you can only, that's the uppermost amount that can be reclaimed, and 85% of that is the upper limit. So if an assessment...
No, it's not 85%
sorry,
of that. It's 85% of what you've actually outlaid, or
Yes.
the cap, whichever is the lower.
Correct. So in an assessment period, if you have, if you've paid for say you've paid for 2 months and it exceeds that cap, you obviously, if you recouped all of that in the first assessment period, it would be capped at the 646 amount. Whereas if it follows into the second assessment period, the cap doesn't apply. So that in the same way. So the apportionment means that you get more back.
Yes, what your point is made, the apportionment is for the benefit of the claimant, just as much as for the Secretary of State.
Yes, because it means then
Yeah,
you're
got
not
it.
affected by the cap. And that is an important consideration as regards that apportionment as well as serving the other purposes.
Thank you.
My lords, can I give you for your note as well? You asked me where the figure was about the breakdown of the provision of childcare. So that you have it, it's at bundle 1, page 300, and it says it's statistics based on a CAB report from 2014. It says that 90% of providers charge in advance, but 60% charge on a monthly basis. Which obviously means that almost half.
So give me again the reference for that.
It's bundle 1, page 300.
That's the supplementary bundle 1.
Yes.
Yep. Okay.
So that indicates that there's a sizable proportion of providers who are not charging on a monthly basis. So they may be asking you to pay up front, but it may be on a weekly basis. So on that sort of pay as you go, week to week.
Or even on the day, as my lord put to you yesterday.
Yes. My lord, it is the 4th paragraph down.
I've been slow. I don't see 90% charge in advance there.
It's 9 and 9.
Sorry,
and
9 and 10. That's my having.
My arithmetic. No, you're right. It's just my basic numeracy.
My lord, you asked me if there was a clear indication. Or statistical basis.
Sorry,
My lord, that's the
the
closest
fourth
I can
page
find.
300, 4 paragraphs down. Did you say?
Yes, upfront costs are common.
This means that upfront fees
So
are.
it's the paragraph before that.
Sorry, I was reading the wrong paragraph. Even I would have realised that 9 and 10 was 90% if I'd been reading the right paragraph. I see. Yes, all right. Well, there we are. That's based on a CAB survey from 2014. We don't know. I suspect they will have surveyed institutional childcare providers rather than the childminder down the street.
I don't know, they may have done both.
Yes.
So I wouldn't like to say that they hadn't.
No. Okay. Thank you very much indeed.
So I just
No, that's
you
very
asked
helpful.
where it appears, and that's
Yeah, thank
where
you.
one gets that. So, my lord, I'm conscious that you are keen that I finish up quickly.
Well,
So-
keen, but not so keen as to stop you saying everything you want to say.
So, my lord, can I just go back on one other thing that you asked me about yesterday, which was what my argument on behalf of the Secretary of State as to why this doesn't fall within indirect discrimination. And I just wanted to formulate that so that you had a clear basis upon
Thank
which
you.
you were saying that. So, my lord, our submission on that is indirect discrimination is concerned with a single neutral measure or rule which produces the
Sorry, is this dictation speed? Is this a proposition you're
Yes, so my lord, I
could you
want
do
to
it a bit slower then?
Of course. So the uncontroversial proposition, indirect discrimination is concerned with a single neutral measure or rule which
Okay.
produces the disproportionately prejudicial effect.
Yeah.
Universal credit isn't a single measure in that way. It applies different conditions as to how different
You're going too fast. Provides different conditions. Yeah.
as to how different elements will be paid.
Yeah.
So we say that the correct analysis here
Yeah.
is not that universal credit as a whole produces the disproportionate effect or treatment. Properly analysed, it's that one rule or one condition governing one part of universal credit produces a disproportionately prejudicial effect, and we say the focus should be on that rule.
Namely.
The childcare, the proof of payment rule.
Okay.
We say it's not indirect discrimination to compare a different rule or condition, because the true comparison...
Not so fast. It's not said again.
Because we say it's not a true comparison there, because that's between the operation of two different rules, as opposed to the single neutral rule. And it's the submission on behalf of the Secretary of State that that formulation follows SC at 49 and 50, which is the classical exposition of what indirect discrimination is. And that's, of course, secondary to the point that we say that there isn't really any difference between paying on a liability basis in housing and in childcare, because ultimately both are paid in arrears.
Yes.
So, Ella, can I just finish off the submissions then on objective
please.
justification? So, my lord, overall we submit that the judge was wrong in this case to conclude that he didn't have to apply a particularly wide area of discretionary judgment, save and to the extent that he referred to the proof of payment rule being contained in the statutory instrument. Our submission is that it's clear from the judgment that he didn't confer a particularly wide area of judgment. We say that's contrary to paragraph 158 of SC, which makes clear that a low intensity of review is generally appropriate, where what's in issue is a social and economic policy in the field of welfare benefits, so that the judgment of the executive will be respected unless it's manifestly without reasonable foundation. And we say, for the reasons set out yesterday, that he was wrong to apply a weighty reasons test, because this difference, the difference in treatment relied upon was not related to stereotyping, stigma, or inclusion. And my lord, as regards that, that's also set out at paragraph 103 of SC as well, as being a particular feature of European cases where the weighty reasons rationale is applied.
Well, it may have been on the facts of those cases, but not as I read them, an essential ingredient of applying weighty reasons. As I read the European case law, it simply says that where you are dealing with discrimination, whether it's direct or indirect, on one of the grounds which are protected grounds, of which gender or sex is one, then you've got if you like, a countervailing reason for scrutinising the measure more carefully, and therefore you've got a tension between that, the ground for discrimination on the one hand, and the fact that this is in a field of social security benefit on the other. And the latest judgment from Lord Reid in SC seems to me to suggest that you have to weigh those two together and come up with something which is not a tick box exercise.
Yes, but he particularly singled out and particularly alluded to the fact that when it comes to weighty reasons, that the analysis of the European Court had given way to saying that weighty reasons came in where stereotyping was involved. I don't know if you want to look at that at paragraph 103 of his judgment, but he specifically refers to that. And in my respectful submission, that is at one with what was said in the AM case, doubting whether or not weighty reasons could ever come into indirect discrimination cases at all. And it's clear if you look at paragraph 158, he referred back to the considerations that he said would inform whether or not weighty reasons would be required to the earlier part of his judgment, including paragraph 103. And in a nutshell, we say that the rationale for the rule, the policy alternatives, the potential difficulties for some caused by pain in advance were all in contention at the time. The important point is the Minister was aware of the issue. The answer was not to change the model. It was to look to providing support through other means, like the Flexible Support Fund. And again, we say in the context of this benefit, it also has to be seen in the wider context of provisions like the free childcare offer, which means in any event, for some of those with the highest childcare costs, almost the entirety of those costs would be free. See Neve Parker at paragraph 41. And we say here, as was set out yesterday, the judge went too far in this case, insofar as he relied on an alternative that he said had not been taken into account, but which ultimately he found may not have provided the answer in any event. So again, we say relying on the approach taken in Tagire that I showed you yesterday in paragraph 182 of SC, the correct focus ought to have been on the compatibility of the measure. It doesn't permit the court to come to a conclusion based on policy alternatives which it said weren't considered. Still less those which the court accepted would still be problematic and wouldn't be a full answer to the issue. And of course we say here, in any event, the Minister was aware, officials were aware of the issue of upfront payments and had reasons for not having a model that was based on an invoice basis. And then having regard to the overall argument, we say that there was clearly a rational connection between the objectives pursued by the legislation with the twin aims of compensating childcare costs, addressing fraud and error, and ensuring simplicity, which meant that ministers were more than entitled to come ultimately to a system based on proof of payment of childcare costs. My Lords, my Lady, at paragraph 77 of Neve Parker, she set out a response to all of the alternatives.
So which paragraph is that?
That's paragraph.
So which page is that? Which bundle?
Sorry, it's in bundle 3.
Page?
Sorry, I'm just coming to it. 607.
If it's bundle 3, it can't be 607. Is it bundle 2? That's bundle 607 is the first paragraph of her first witness statement.
It is.
So where's paragraph
77, which is at page 627. She said out of paragraph 77, the claimant may suggest alternatives to the current system are as obvious. This is simply not the case. Department officials.
Just sorry. before you start reading us all this, what's the point you're going to?
Well, my lord, this sets out the response. I took you yesterday to the alternatives that were set out in the claimant's grounds to the system based on proof of payment. And I'm setting out that this is her response to each of those, and that she says in terms that these are considerations.
Okay, you want us to read these?
Yes, please.
Is it something you want to read out to yourself, or read it, or is it something? Is it something quicker for us to read ourselves?
Yes, certainly.
Which passage do you want us to read?
It's paragraph 77 onwards, when she
Sorry, paragraph. I didn't hear.
77
Yeah. Oh, just 77.
onwards. No,
Yes, but
because
to
she
where?
sets
Up to where?
out,
Just tell us where to read
paragraph
to.
83.
83. Okay, thank you. Well, this is really summarising all the material you showed us yesterday.
It is, but it's addressing all of the alternatives that were set out in the pleaded grounds.
Okay. Yes.
Well, I was going to move then, if I may, to ground 4,
Yes.
which is the application of Johnson to this case.
Yes.
Johnson's at tab 23.
Yes.
My lord, picking up Johnson at paragraph 2 at G, the issue in Johnson was a distinct one, that the system for identifying income earned didn't accommodate the fact that people who were paid their salary on a particular day each month, such as on the last day, could be paid on a different day if their payday fell on a weekend or a bank holiday. That meant that sometimes they had 2 payments within one assessment period.
I mean, your point simply on Johnson is really what both Lady Justice Rose and what I said. This was a very highly fact-specific oddity in the payment system, which didn't in any way undermine a fundamental principle of the universal credit system.
Yes, and what
It was, in a sense, it was a way of ensuring that it was monthly assessment rather than factitiously 2 payments coming in 1 month just because of banking days.
precisely, and what was said to be irrational in that case was the failure to do anything about it.
Yes.
So that was the core of it. And what was accepted in that case was that the application of the rule was arbitrary and that it didn't pursue any policy reason
Yes, well, that-
in the Act whatsoever. And in paragraph, I think it's 50, paragraph 50 of the judgment, that what was essentially under challenge was a decision not to fine-tune the system so as to produce or to overcome the problem that was being caused. So again, it was accepted by the Secretary of State in that instance that the outcome was arbitrary, that it was complete happenstance and caused real disadvantage contingent only on because of the day that you got paid. That's at 68. And what it ultimately came down to, and this is at paragraph 76 and 82, 76, there wasn't any justification for not crafting an exception. And at paragraph 2 of the judgment, what wasn't accepted was that the computer program in universal credit couldn't be modified to overcome the problem. paragraph 91 of the judgment, reliance was placed on the fact that there was nothing to show that the problem that had arisen, that of advance payment, was highlighted to the minister in a decision taking not to do anything about it.
Yeah. So you say totally different from this
The
case.
other factors included that it was known that 85,000 people would be affected. 95, the claimants had no power to put matters right themselves. And again, at paragraph 97, the court stressed the complete arbitrariness of that outcome. My lords, for all of those reasons, and in particular the reasons that you set out in this judgment, you say this case bore no reliance, and that the judge here was wrong to stigmatise this scheme in the same way that the scheme in Johnson was stigmatised. We say that the proper approach is that reaffirmed in SC at paragraph 146, where the court cited, my lords, I won't go to this because I know you know it, the Hammersmith and Fulham case, where a statute has conferred a power on the Secretary of State which involves the formulation and implementation of national economic policy, and which can only take effect with the approval of the House of Commons. It's not open to challenge on the grounds of irrationality, short of the extremes of bad faith, improper motive, or manifest absurdity. That was the approach that ought to have been applied here. And again, we say the judge here was wrong insofar as he relied, at paragraph 175, on the position in Johnson that there was no evidence that the potential issue had been drawn to the attention of ministers.
Yeah,
and
you've made that point already.
Yeah. So anyway, my lord, that's, we say, you're quite right in terms, this just wasn't a Johnson case. My lords, can I deal then, and I can do this very quickly because it follows on from everything else I've said, with ground 5. This is just the point about whether or not the proof of payment rule falls within Article 8 or Article 1, Protocol 1. My lords, these principles are well known. So what was said in the case of M, which you've got at tab 1, paragraph 14, was that whether or not a measure came within the ambit of Article 8 was a value judgment. So the approach to be distilled from the jurisprudence was that the more seriously and directly the discriminatory provision impinged upon the values underlying the substantive article, the more readily will it be regarded within the ambit of that article and vice versa.
I'm quite surprised you're pursuing this point in the light of what was said in SC.
Well,
it's dead against you.
In the Supreme Court or in the Court
Yes.
of Appeal? Because what I was going to say about SC was that what was ultimately said, certainly in the Court of Appeal about it, at paragraph 57, was that you shouldn't focus on the economic consequences, but rather on the way that the benefit was the way that the state demonstrated respect for family life. And what was said at first instance was that made clear it wasn't the end of the analysis, because there's no need for any adverse impact other than the denial of the benefit in question. And again, I'm simply coming back to the point that the issue isn't the denial of a benefit in this case. What's being challenged is how it's being paid and the timing of it.
Yes,
So-
but why has that got to do with whether it falls within the ambit?
It doesn't.
Because our submission is that it's not, if the ambit is concerned with the denial, if you have to show that the adverse treatment is the denial of the benefit.
But do you have to show that?
Well, that's what it says at paragraph 57 of
Of
C
what?
in the Court of Appeal.
Well, okay, but I'm not sure it does
say.
say that. But in any, if you need to make that good, but you also need to show that it's consistent with SC in the Supreme Court.
Paragraph 41 of SC, it seems to me, is absolutely dead against you on this point.
So did you say paragraph 41?
Well, that's a start. welfare benefits which are designed to facilitate or contribute to family life by supporting families with children are likely to fall within the ambit of Article 8 for the purposes of complaints under that article taken together with Article 14. Since child tax credit is payable only to adults who are responsible for children, etc., etc., I don't see any convincing basis for distinguishing it from benefits with which those other cases were concerned. Well, here we've got an element of universal credit which is only payable to parents with children in relation to the childcare of those children. I would have thought it's absolutely on all fours with paragraph 41.
Well, my lady, when you actually look at the analysis that was applied in C, which sets that out in more detail.
In C, sorry.
So if you look at it in the Court of Appeal and the analysis that was applied, so
Why would the Court of Appeal trump the Supreme Court?
It's not that it trumps it. I'm simply pointing out that it breaks it down into a further analysis as to why, in that instance, it fell within Article 8. So it wasn't just saying that it was simply the nature of the benefit that placed it within Article 8. The second part in C at paragraph 7 was that there was, and this is said...
But paragraph 7 of...
Sorry, paragraph 57.
If this is important to your submissions, you must show it to us.
It's at tab 21. My lord, this section is all to do with the ambit of Article 8. So it's a lengthy analysis. At paragraph 57, if you look at the end of that paragraph on the other page.
So page...
So page...
Yes, 5707, yeah.
Yeah.
Okay,
So
which bit do you want us to read?
So at the top of the page, then the point that's being made.
Shall we just read it? Shall we just read it?
Yes. And if you read to the end of that
Done that.
So my lord, it's simply that the second part of the analysis, it's not simply about the modality, but that an additional part of it is that the benefit or the adverse effect that needs to be demonstrated is that the benefit isn't paid.
Well, that's just the
That's
facts.
not facts of the case.
Well, I think
And
that
that's
it's
not what Lord Reed says anyway.
I mean, you seriously suggesting it wouldn't fall within Article 8 if only half the benefit was paid?
Well, my lord, what I'm saying here is that the essence of the complaint is about the timing of the benefit when it's paid. If it's paid before you pay the costs or after, as opposed to being concerned with
Right, okay.
whether or not the benefit. So here, for example, when one looks at the evidence that's relied upon, for example, that of witness W, who we looked at yesterday, the benefit is in fact being paid to that individual. The complaint is about...
But if the evidence is that the effect is that a benefit that was otherwise available is not available because they can't afford to take it up, wouldn't that fall within the ambit of Article 8?
Well,
Why? Because it would have the same deleterious effect on family life, the unavailability of a benefit which is intended to benefit family life.
yes, and obviously the other part of our analysis is that doesn't quite follow here, because as we saw in the claimant's case, her benefit, her universal credit payment went up.
But that's in the claimant's individual case. We're talking about the tendency of the scheme as a whole.
Yes, I do understand. I understand that.
Well, okay, I see what your point is.
And my lords, that's why we also say if you apply the analysis under Article 1, Protocol 1, that doesn't follow either, because again, Article 1, Protocol 1 is concerned with a proprietary right to something. And we say in a proper analysis here, it's not about a proprietary right to something. The complaint is about when the benefit will be paid, as opposed to the right to it. See again the evidence in this case of the individuals who have in fact been paid the benefit.
Is the claimant relying on A1B1? I didn't realise that that claimants were relying on Article 1, Protocol 1. I thought they are.
Yeah, the judge found on both bases
Right.
at first instance.
But they only need one.
They only need Article 14.
Yes.
Oh, I'm so sorry.
Well, they only need
We
Article 8.
don't rely directly on A1P1.
I didn't think you did.
Just as ambit.
Yeah.
Ambit of A1P1.
Yeah.
Yes,
Yeah.
no, absolutely.
No, we're at cross purposes, but you only need to be within the ambit of Article 8.
Yes.
Yeah.
Yes. Mario, can I move then to ground 3? And that's really about how the judgment was framed. And the fact that the judgment was framed here, if we look at paragraph 174, that it was framed in general terms.
So which paragraph do you say asked us to look at?
174.
Yeah.
Now, my lords, of course, I understand, my lady, that the order that was finally made in this case was made on the basis that it was the operation of these regulations in respect of the claimant, and that it was contrary to Article 8 as applied to her. But the judgment is framed in this general way. And my lord, when you look at the case of Matheson at tab 12,
Yes.
page 323. And it's the part of the judgment that goes over the page. So the court was being invited there to read down the regulations. And the Supreme Court declined to do that on the basis that decisions founded on human rights are essentially individual. And one sees at paragraph 61 as well. That it was agreed that the remedy should be tailor-made to the particular position of the individual.
So what's wrong with the judge's order?
There's nothing wrong with the order, I understand.
But you can only
that.
appeal against the order.
Yes, but there's still a point about the way the judgment was framed and whether or not it was right that it was framed in the terms that it was framed in. And that was an issue of some significance as well. in the Joint Council of Immigrant Welfare case. That's at tab 29. And it's picked up at 116.
I still haven't quite understood what you're asking us to do. If suppose you lose on everything else,
Yes.
you say there's nothing wrong with the order. So what are you actually asking us to do?
What I'm saying is any judgment should be framed by reference to the individual's
I
circumstances.
don't understand what you mean by the judgment is the order. You mean there's something wrong? Do you mean we
Well, I
should be
think-
correcting the judge's reasoning?
What I'm
I know judgment is an ambiguous term,
Yes.
but what for ease of, let's call them the order
Yes.
and the reasons.
Yes.
You're not saying anything wrong with the order.
No.
So you're asking us simply in our judgments to say that part of the judge's reasons are poorly expressed. Is that what you're asking us to
The
do?
reasons shouldn't have been expressed at the level of generality that they've been expressed at 174.
Well, I've gone back to the grounds of appeal simply to try and make head or tail of what these submissions are. And ground 3 is that the court ought not to have made a finding that regulations 33(1) ZA and 34A were incompatible with Article 14. So what you're saying is you could have said that they were incompatible with Article 14 so far as the individual case was concerned,
Yes.
but not generally said that there was a declaration of incompatibility.
But the reason why that's important, if you look at the Joint Council case, if you pick that up at tab 28, sorry, it's tab 29.
Which tab do you say?
29. I thought
29.
my tabs followed.
No problem. That's what I didn't hear. Yep.
So, my lord, if you pick up at paragraph 116, the claim was, so it hadn't been brought by individuals, it had been brought as a challenge to the validity of the
So sorry, just give me one moment.
provisions.
116, did you say?
Yes.
Yes.
So, I won't read it all out, but all of that analysis is to do with the high hurdle that's involved when what's under challenge.
Well, it's quite helpfully encapsulated on page 982 in subparagraph 3 of the head note. Quite neat encapsulation of the principle, isn't it?
Yes. So, legislation will not be unjustified and not unlawful unless it's incapable of being operated in a proportionate way in all or nearly all cases. And then at 119, given that the scheme is clearly incapable of being operated in a proportionate way in most individual cases.
But if we read the judgment and the order together,
Yes.
there's really no ambiguity. It's as my lord
Yes.
puts it, it's an imperfect expression of the conclusion that has been reached by the court in a challenge brought by an individual
Yes.
concerned with her particular circumstances and the application of this legislation to those circumstances.
Yes, I agree with that. It's simply, it is the way that it's expressed. And obviously any
So all you want us to do, I'm trying to get at what you want us to do. What you want is, if you lose on everything else, and you even lose on this, you want us nevertheless to say that Mr. Justice Chamberlain expressed himself inappropriately widely in paragraph 174.
Yes.
Okay?
The consequence of that would be that any further challenge would have to involve a factual demonstration that the circumstances of the individual claimant brought her the right to the same remedy. So every claim would have to be brought individually.
Yes, I mean, obviously, the Secretary of State would take into account the implications of any ruling in an individual case. Well, it obviously also goes back to the evidential basis upon which the determination is being made and the distinction between individual circumstances.
Was there ever a claim for a declaration of incompatibility in this case?
Can't remember. I might have.
Well,
Does
so
not
it was any question looking at the ground, so.
I would need to go back and just check in the.
Okay, well, don't worry, Mr. Butler can tell us.
Well, unless I can, my lady, unless I can assist.
Thank you very much, Ms. Dobbin. Sorry, I should just check. I don't think my lord and my lady have any questions.
No.
I've just found page 170 of the core bundle, paragraph 61. The claimant seeks a declaration that regulation 33(1) is unlawful.
Well, well, we'll have to ask what that was meant to mean, or
That's the only declaratory relief that was sought.
am I being slow? Is this because it isn't primary legislation? I am being slow, sorry.
And there was also a rationality challenge.
Yes. Yeah. Okay. Yes, thank you.
My lords, my lady, could I begin by handing up another bundle? It's only got 3 documents in it. If I may, I won't introduce those now, but so that we've got them when I come to them.
Yes, that makes sense.
Thank you so much.
If I may be permitted to make a few introductory remarks before I give you the structure of my submissions. There is no challenge by the Secretary of State to the judge's finding that a central aim of universal credit is to encourage work by making work pay. And universal credit includes a childcare element because the government has identified that for many parents, funding for childcare is vital to enable them to make work pay. Take a prosaic example. If you earn £9 an hour and childcare costs £9 an hour, self-evidently you need the childcare element to make work pay. This case doesn't involve a challenge to high policy decisions of that kind. It concerns the more prosaic matter of the mechanism by which the Secretary of State has sought to implement the objectives of the scheme. That is the proof of payment rule. The problem is that the proof of payment rule, we say, creates a catch-22. You can't get the money needed to pay for childcare until you have paid for the childcare. So as the judge found, the proof of payment rule creates perverse disincentives to work, which, in his words, are antithetical to one of the underlying principles of universal credit. And so, to take one of the examples identified by the judge, the claimant desperately wanted to work, but the difficulty in paying for childcare up front led her to cut her working hours from 37 to 25 and a half hours per week. And as the judge also noted, the Child Poverty Action Group told the Work and Pension Select Committee that this was the most common problem related to the childcare element of universal credit. So, just assuming for a moment that Article 14 is engaged, clearly I need to deal with the challenges to that, we say that Mr. Justice Chamberlain was right to conclude that the Secretary of State hadn't shown that the proof of payment rule is justified, and he was similarly right to conclude that the choice of this rule by which to implement the aims of the Universal Credit Scheme was outside the range of rules that it was reasonably open to the Secretary of State to choose to implement the aims of the scheme. With that said, could I give you the structure, my proposed structure, subject to court preference as to how I take it, proposed structure of my submissions? First, I just wanted to emphasise the nature of the appeal court's task. Second, I propose to make a few points to respond to some of the questions the court asked yesterday about the proof of payment rule and the proof of liability rule. Third, to deal with disproportionate prejudicial effect on women. What's the test? Fourth, the approach to justification, as set out in SC. Fifth, to look at whether it was open to the judge to conclude that the choice of rule to implement the childcare element was irrational. And then there are 2 points I think I can deal with quite quickly. Sixth ambit, and seventh, the question of the framing of the judgment. So if I may begin with the first topic, the
Can I just ask one small point? Occurring to me recently, I think we won't be able to get away from the phrase proof of payment rule. That really doesn't quite go to the heart of it, though. It slightly biases the question in your favour. It's not just about mechanics of proof, it's fact of payment rule.
Yeah. That's fair.
I don't mind you going on calling it proof of payment rule, but I just thought it was worth bringing that point out.
Yes,
So
yes,
you agree.
that's a fair characterisation. So first, the appeal court's task, and as this court will know, its task is not to ask afresh whether the rule is disproportionate or irrational, but rather to ask whether the judge's decision on those matters was wrong.
That's only half right, isn't it? Disproportionality, there's some authorities which you're going to remind us on. Irrationality, there's only one possible answer, isn't there?
Yes, but it's arrived
So
at
it's a matter of law, effectively.
So I suppose that's right.
Yeah.
So could I just show you one authority on that? It's in the first volume of authorities at tab 18. against the Chief Constable of Greater Manchester Police. This was an Article 8 challenge concerning the proportionality of the police's decision to disclose certain information in an enhanced criminal record certificate. And the question was to what extent an appeal court should revisit the first instant judge's assessment of proportionality when that assessment was based on documents. And the Court of Appeal, so this is a judgment of the Supreme Court, the Court of Appeal had suggested that it had to be shown that there had been a significant error of principle. The Supreme Court held that that put the test too high, but that it did have to be shown still that either there was an error of principle or an identifiable flaw in the judge's reasoning. Can I show you that? It's page 539. And if you would please read paragraphs 64 and 65.
Yeah, well, that's fairly traditional stuff.
Yes.
I see why you refer us to it.
Not controversial material. And could I ask you just to look at one further passage, which is on the previous page, page 538, where Lord Carnworth cites what Lord Clark said in Abella. And if you could please just read paragraph 60, that's entirely consistent with what Lord Carnworth said in this case. Just to make the point that the greater the number of factors in play, the slower the appeal court should be to interfere.
Yeah.
And so that's what I wanted to show you in this case. In our submission, there is no error of principle, nor any identifiable flaw in Mr. Justice Chamberlain's reasoning. Now, we spent quite a long time yesterday looking at the underlying evidence. But we don't understand there to be any challenge to the accuracy of the judge's summary of the evidence or to his summary of the ministerial briefing papers.
It may depend exactly how you formulate it. There clearly is a challenge to what is said to be the judge's finding that the minister didn't bring his mind to bear on this issue. That's to say, on the possible objections to the proof of payment rule.
Well, I think what you're being invited to conclude by the Secretary of State is that it can be inferred that the minister must have had those matters in mind. It's certainly not recorded in any of the documents you were taken to yesterday.
Well, I think that's probably right, but there's a basis shown for the inference, which was that the point was considered by officials, and it's reasonable to infer that the minister is aware of and on top of the issues which officials have considered. Well, there's nothing wrong with that, is there?
Well, yes, one can't assume that what's in the mind of the civil servants is in the mind of ministers.
But there's a limit to how far this exercise works. You can't cross-examine the mind of the minister. We'll never.
No, but that's the function of evidence in the judicial review proceedings. And the finding made by the judge was that the defendant the Secretary of State had a fair opportunity to respond to the matters advanced and hadn't shown that any of this material had been considered by the minister.
So what are you talking about? That we should have had a witness statement from Lord Freud saying, no. I thought about this point?
No, it could have been said by Ms. Parker that this matter was presented to the minister and discussed with the minister, or although the ministerial briefing paper doesn't record it, actually the minister was told about the discussion which civil servants had with the stakeholder groups.
One sees that sort of information in these types of challenges time and time again.
Exactly.
It comes from the civil servants. You don't get the minister involved, but you do see a civil servant going on oath and saying, yes, you know, whatever the paper says, I can remember that I was in the room with the minister and I said X, Y, Z.
Yes, but perhaps my point is of a slightly different character. It seems, it would take some persuading that these cases will turn on whether every point that was carefully considered by civil servants can be demonstrated to have passed the desk of the minister.
Well, when one is faced...
What's the magic of it passing the desk of the minister?
Oh, because the minister is the... I'm going to come on to show you in relation...
The minister makes the regulations.
The minister is the author of the regulations. The minister is the decision maker. And the question of whether the minister considered the matter... I'm going to deal with this later in my submission.
All right, well then
to give you the short answer, the reason that it matters is because it goes to the margin of deference. Because you can't defer to a judgment that wasn't made. And as I'll also show you, there is Court of Appeal authority that if the minister didn't consider it and no post hoc justification has been given, then how can a proper justification for the measure be made out? And of course, one has to bear in mind that although this is judicial review, in a convention challenge, it is the minister who bears the burden of justification and the burden of advancing the evidence to make out that justification.
Thank you. Well, as you say, that's helpful, but you're trailing a point you're going to come back to, so I
point.
won't press you on that at the moment. But your point at the moment is there's no challenge to the accuracy of the judge's summary of the evidence.
Exactly, and nor could there, we say, be any challenge to the weight placed by the judge on particular pieces of evidence. And so in those circumstances, it's in my submission unnecessary to cross-check the judgment against the underlying evidence, save to the extent it suggested that there's an inaccuracy in the summary. But in case you want to do so, I'm very grateful to Ms. Jones for producing a marked up version of the judgment. It's the first tab in that bundle I handed up. And what that does in the margin of the judgment is to give you the cross-references in the appeal bundles to the material he cited.
That will be extremely helpful, and we're grateful to Ms. Jones as well.
So that was my first point, my first topic. My second topic, second set of points, relate to the proof of liability and proof of payment rules. And I'm afraid it's a bit of a scattershot selection. There are 8 points.
Well, that's fine. I'm sorry, I had a different heading. You said response to various, but this is it, is it?
This is it.
Yes, right.
There's a response to the court's questions and a few additional points of my own.
Okay, so a number of self-contained points. That's fine.
Exactly. And the first point, which I think the court has appreciated, is that, of course, the catch-22, as I put it, arises when you first start work.
Yes.
But it also is liable to arise during the school holidays, when the need for childcare is liable to increase significantly. And that was expressly noted by the judge. Just for your note, paragraph 49, paragraph 151C.
My lady's obviously on top of this point. Just spell out why.
So if you're a working parent and it's your child is of school age, during term time you won't require paid childcare during school hours. When it comes, let's say, to the summer holidays, your child breaks up from school.
Well, I understand I understand why you'll need more childcare in the holidays, My point was why the catch-22 applies.
Because when one in the period immediately before the summer holidays, one would have received the childcare element of universal credit, reimbursing the payment for the term time payment. Let's say it was £100 a week during term time. You then have to find the money yourself up front to pay your childcare provider for the holiday provision. So if it goes up from £100 to £500 a week, you have to find that money up front. And so you're
the extra 400.
Extra 400.
Isn't there another angle, possible angle, in some cases to this, which is that assume the person is in full-time employment with paid holiday, which is not everyone, but it's some people. She takes her paid holiday during the school holidays. Therefore, she doesn't have a need to pay for childcare. That gives her an opportunity to amass the money, or at least some of it, necessary to deal with the catch-22 problem.
Well, it's not amassing money, it's just getting the money back that she's already paid out.
No, but I'm saying the catch-22 is you don't have the money. Now, some people will, because they'll have savings and other resources on which they can draw to deal with that. Some people won't. But the person who has been able to continue getting paid for a period of a couple of weeks without having to pay the childcare because she's on holiday and able to provide it herself will but necessarily have the opportunity to save resources, won't they?
Well, let me put it this way. To the extent that an impecunious parent has borrowed money to pay for the childcare up front and then gets the money back and discharges the loan in that way, they'll be in a broadly neutral position when the universal credit payment is made. So they won't be amassing anything through universal credit during that period. I accept that if a parent has a period in which they have generally lower expenses and are still paid by their employer, that might theoretically give rise to an amassing of resources. But I don't think that was the point that my lord was making.
Well, that was the point.
Right.
That was the point.
Well, it's a point that really turns on the evidence, and the judge's findings on this point, that the catch-22, not his terminology, but that the catch-22 also arises during the school holidays, was supported by the evidence.
Well, in a sense, it's helpful to have the evidence because we wouldn't, only with real cases in front of you can you get a feel for these things.
But sorry, that wasn't the subject of anecdotal case-specific evidence. That was based on the survey from Save the Children, and that's what he cross-refers to. He refers to paragraph 18 of Ms. Lawton's witness statement, which in turn cross-refers to the Save the Children study.
But that too is not all hard. I mean, it can be a problem. As my lord has demonstrated, depending on your circumstances, you can, if you take your holiday immediately after the end of the school holidays, you will have a period during which you have no childcare costs and can amass, perhaps is not quite the right word, but you can accumulate money with which then, when you have to go back to work but the school holidays are going on, pay the greater costs or fund, in cash flow terms, the greater costs of childcare until you get it back as universal credit. What all this illustrates is that these situations are almost infinitely variable.
Of course. And
the school holidays is simply a particular way in which this can cause a problem.
Yes.
Whether it will or not depends.
It's fact dependent. Of course it is. And it's no part of my case that the catch-22 arises in every case.
Yeah.
The point that the judge accepted is that it's a structural issue which has a tendency
Yes.
to cause problems.
Yeah.
So the first point I was making was simply that the catch-22 doesn't only necessarily arise at the outset, but may arise during the course of a parent's working life.
I mean, but a real problem is always going to be quantifying how big a problem this is. Speaking for myself, it seems to be obvious common sense that it has a tendency to do this. And there will be individual cases, including those which are evidenced here, where that tendency does actually eventuate But the real difficulty is how often it eventuates, how big a problem it is. And
Well,
that's something which I think is really certainly unquantified on anything we've seen, and it's really unquantifiable.
Well, with respect, my lord, it is quantified in the evidence, and that's I'm trying to resist going into the evidence because this isn't a merits review.
I'm very happy if you go to the findings, but
could I just to address my lord's point?
Yes.
There's no quantified evidence on this. Could we look at Kate Lawton's witness statements? It's in Supplementary Bundle Volume 1.
yes.
Page 226. So I haven't shown you the front sheet, but this is Ms. Lawton for Save the Children. And at paragraph 18, at the foot of 226, third line, she says the childcare element of universal credit appears to be designed with the intention that once the first month is covered, parents can then use the previous month's childcare element to pay for the following month's costs. This may work in cases where costs remain the same on a month-to-month basis, but our research has found that in contrast to rental or other bills, childcare costs are highly volatile and subject to regular fluctuations. She then refers to exhibit STC 3, and one sees that at page 310. So that's the front sheet of that Save the Children report.
Yeah.
And if we could go into it at page 323.
Yeah.
The second half of that page has figure 2, average monthly cost increases in the holidays in England.
Oh yes, but this just shows that costs will go up in the holidays, which I've got no difference. But the question, the extent to which that causes a problem in practice will depend on many other considerations, such as how many savings the parent may have, whether they're able to take advantage of the phenomenon that my lord just referred to.
I don't accept that phenomenon. I want to come back to that, but
okay.
I accept that of course it depends on the parent's circumstances. And if one's dealing with a parent who has resources saved up, then of course this problem's not going to affect them.
But when I said it's unquantifiable, that's what I meant.
Right.
I didn't mean that you can't put figures of this kind, which are helpful and show how the problem can arise.
Yes.
It doesn't show how often the problem does arise in real cases.
No, but by case, I don't need to show that. Could I just come back to my lord?
Sorry, I hate to interrupt. Can I just make the point about what you have just been taken to about average monthly
isn't this
increases?
something for reply, Ms. Dobbin?
Well, no, it's not. It's just factually. If you look at it, it refers to monthly increases in child holidays. It relates to 2-year-olds who are getting the free 15-hour childcare and the free 30-hour childcare. So it's a limited. It's not referring to everyone. It seems to be the specific problem that if you get 30 free childcare hours a week, you may not be able to stretch them over the summer holiday. So it's a different group of people that's referring to.
Is that true about the first table? Oh, I see. No, it's the second table that's being relied on.
So
I'm not a great fan of council getting up in the middle of other council submissions, but that is actually a fair point, isn't it? Because about the second table. Because if this is only 2-year-olds and... No, perhaps it isn't a fair point. Well, you have understood Mr. Dobbin's point, or perhaps you haven't, but what do you want to say about it?
I wasn't proposing to take you through the whole of this document, but it is replete with similar graphs.
Yeah.
Page 330 and onwards, which in my
submission... Well, I think perhaps we don't need to go there for this reason, Mr. Butler. I don't think we're really I don't think we're really at cross purpose saying anything different. Of course, various figures can be put of the sort that appear here, and this, I wasn't seeking to suggest otherwise. What you can't tell is in how many cases this actually causes a particular problem, precisely because everyone's circumstances are so different.
Yes.
We know it does cause a problem in some cases.
All we've got are the NGOs, Save the Children, Gingerbread, and so on, the Child Poverty Action Group, saying this is the biggest problem.
Yes, and that's not a criticism of anyone. It's the nature of the kind of phenomenon you're dealing with. You could imagine a piece of research, but it would have to involve huge numbers of people and ask incredibly sophisticated questions. And nobody has ever done that, and nobody realistically could.
And nor is that needed for a challenge of this kind. But could I just come back to my Lord Justice Warby's example? If one gets to the point of the summer holidays and one is reimbursed for the childcare costs that have already been paid out, which were taken out on the basis of a loan, and so one gets to a cost-neutral point, one then, let's say for the sake of argument, gets 2 weeks off work in which one can look after the child oneself, so one doesn't incur childcare costs at that point. One isn't making any savings. The costs of living don't decrease.
Yeah, of course, if you assume that every penny of every pound is absorbed by some other cost all the time,
yes,
then you're right.
Yes.
There's no opportunity for saving, but that's quite a large assumption.
Yes, but if one doesn't, if one eats less or doesn't buy as many clothes or whatever when one's on a holiday, then of course. But
I don't. Well, I'm not. Maybe I misunderstood my Lord's point. My Lord's point, I thought, was that they won't have any childcare costs.
No, of course.
During that period.
But then one's not getting the reimbursement, and so at the point when one does then have to pay for summer holiday childcare after one's 2 weeks leave, one faces the cliff edge rise again.
Yeah, but the childcare costs are only ever reimbursed to the extent of 85% or the cap.
So the marginal 15%.
So there's an assumption built into the system that people are going to have to draw on their resources, whatever they are, be they universal credit or that part of their salary, which is unaffected.
The 15% on structurally, what must be assumed is that the salary must be enough to cover that 15%.
Right.
Otherwise, work doesn't pay. So, with a slight digression, that was my first point.
I'm sorry.
No, it's all helpful. Yeah.
The second point is that we say a proof of liability rule would resolve the catch-22 in that you would get the childcare element even if you'd been unable to discharge your liability. So if one has a proof of liability rule, one gets the payment from the universal credit even if the liability hasn't been discharged. So it breaks the catch-22. And in that respect, it would work in exactly the same way as it does in relation to the housing element. Now, I accept that for those who couldn't settle their liabilities by the due date, then the registered childcare provider, or the landlord in the housing example, would have to wait until the universal credit is paid, or take action for the breach of contract. But the judge expressly recognised that. And just for your reference, that's paragraph 173I. But the point I wanted to make is that from the provider's point of view, there is a world of difference between providing services or accommodation to someone who can't pay up front and knowing that there is no way that they're going to be able to get hold of the money because universal credit depends on proof of payment. There's a world of difference between that and providing services to someone who can't pay until they get their universal credit payment.
But again, it's a question of cash flow, isn't it? Because the the childcare provider, unlike the landlord, it's not a steady source of income because the amount of childcare will fluctuate from time to time. And it may well be that the reason that the childcare provider wants the money up front is because he or she has their own cash flow outgoings and expenses that need to be met up the line. So whilst I take the force of the point that you make, which is that there is a degree more security involved because the state is actually going to pay, and therefore you've got that extra layer of comfort, it may not be a complete solution because they still may not be prepared to provide you with the childcare unless they're paid on the nail.
I completely accept that. It's not a complete solution, but one, for the purposes of the proportionality analysis, which I'm going to come to, one doesn't need a complete solution in order to demonstrate that the rule chosen is disproportionate. If there's another solution which ameliorates the disadvantage, that is a way of demonstrating disproportionality. Lim
Which
3
is certainly on the traditional four-stage test.
Yeah, Lim 3 Bank Mellors.
Yes.
But that's where we are now in light of SC. Well, just to trail the point, it had been said that the four-stage Bank Mellor test had been displaced by what the court in Humphreys and DA called the manifestly without reasonable foundation test. SC, the Supreme Court says, no, there's no such thing as the manifestly without reasonable foundation test. There's margin of deference, which is a sliding scale, but it's not a test. So what is the test? It's the Bank Mellor test. Now, I accept that I'm reading that in. But coming back to my submissions, the question that my Lord the Vice President asked yesterday, and which my learned friend answered this morning, was what proportion of childcare providers require upfront payments, and the answer to that is 90%, according to the figures in the Save the Children report. But that should be, it's worth noting also, alongside that, the behaviour of childcare providers in relation to the free childcare allowance that's funded by the government. And can I just show you...
When you say upfront payment, you don't mean payment in advance, you mean payment otherwise than in arrears. I mean, what I'm trying to get at is, I would have thought that a very common model, but I don't know to what extent the evidence shows this, with the less formal form of childminder, is you pay per session.
Well, no,
when you pick up the child...
That's not what the evidence indicates.
I'm not clear that what the evidence really shows about and whether it catches that model.
Well,
they seem to have basically the evidence seems to be based largely on what appears from nurseries.
Well, the combined evidence of the Professional Association of Childcare Providers and the National Association of Day Nurseries, I appreciate the nurseries aren't really what my Lord's talking about, but the evidence is that those providers require upfront payments. It's not.
Yes, but I'm just not clear how big a proportion of the providers the people represented by those organisations are.
Yes, I accept that. The best evidence we've got is the evidence that my learned friend took me to, which is the CAB survey, which says 90% require upfront payment in advance. Those are the best figures.
Is upfront payment the same as payment in advance?
Yes.
So if I turn up to a session and say, I'd like to leave my child as prearranged for today while I go to work, and here's my X pounds, that's not counted as upfront payment.
Well, I don't know how the survey...
Well, it may not matter. These are all questions of degree. The real problem is you can't have payment in arrears.
Yes. Can I... This was all qualifying the point I wanted to show you, which is if we could look in Supplementary Volume 1 at tab 4.
Sorry. Labels have come Yes, am I? Yeah, got it. Yeah.
Tab 4, this is the witness statement of Jonathan Broadbury.
So my tabs aren't numbered. What page?
It's page 438.
Yep, got it. Yes.
Jonathan Broadbury of the National Day Nurseries Association. And if we could look to page 440, please. Paragraph 8. One sees that up to the bottom of that page, that if you earn less than £100,000, you're entitled to 30 hours free childcare a week for children who are aged 3 and 4. And then if one looks, please, at paragraph 9, line 4 records that private providers now receive 46% of their income from that form of provision. So it's a very significant part of the work of childcare providers. And then the next point I wanted to show you is in another witness statement. If you please turn to page 453.
.453,
which is in the middle of the first witness statement.
Yep.
Liz Bayram,
Yes.
who's from the Professional Association for Childcare. And paragraph 9 on page 453, line 5, she says this is compounded, this is difficulties for childcare providers, compounded by the fact that most local authorities who administer early education entitlements for all 3 and 4 year olds, disadvantaged 2-year-olds, as well as the 30 hours offer for qualifying parents, pay these termly in arrears. And just to make the point that PACEY is not a 2-bit organisation, it represents 25,000 providers. Get that at paragraph 2 of that statement. So all of that was in relation to the extent to which there might be grounds for optimism that a proof of liability rule would not only break the catch-22, but would provide a workable solution in many cases, which is the inference the judge drew. The third point is that, as the judge found, the problem of fraud and error in the old benefit system arose because it paid claimants based on their estimates of their childcare costs. Can I just show you that, please, in the judgment? Bundle tab 7. It's page 136. Paragraph 170 of paragraph B. And that's for the obvious reason that estimates are inherently liable to be inaccurate. But by contrast, ministers were told that fraud was a small problem under the old system. The problem was inaccuracy through estimates, not fraud. fraud. And can I just show you that? It's in Supplementary Volume 2. Tab 10, page 866.
Yes.
So, page 866. This is the beginning of the ministerial briefing paper dated the 9th of February 2011. And if we look at page 871, this is the annex to that briefing paper. And what the annex is doing is discussing the pros and cons of various options. The second heading, midway between the hole punches, is vouchers. And if you look at the heading cons, under vouchers, we see HMRC analysis suggests that fraud is a very small proportion of overall childcare cost element error and fraud. So the problem was estimates lead to error, not the old system led to fraud. And I'm sorry to hop around, but if we could just go back, please, to the judge's judgment. That's page 140. This is within paragraph 173, letter G. So the first line, no evidence that ministers have directed their minds to the distinction. But then, importantly, third line, neither Miss Parker in her evidence nor Miss Dobbin in her submissions explain satisfactorily why an invoice from a registered childcare provider representing the sums which the parent is contractually liable to pay would be inherently less reliable or more likely to be subject to change in the receipt from the same registered childcare provider.
Well, the only difference, seems to me, is that if you base it on a receipt, you know that the childcare has been provided, or at least you've got more of a chance of satisfying yourself that it's actually being provided.
Yes.
And that's the difference.
Yes.
But that didn't seem to feature as the major justification.
No. I know that my lady asked a question yesterday about whether you can claim the childcare element for childcare that wasn't provided as a result of illness. I'm going to come to that in a moment.
Right.
But my fourth point is that in relation to payments for childcare costs, the universal credit claimant has to submit a receipt. That's the way the system works at the moment. And I can take you to the witness statement if you want me to, but let me just make the point first. That Miss Salvato's evidence, the claimant's evidence in this case, was that she was asked twice in 2 years to provide corroboration in the form of an invoice. You want the reference to that? It's Supplementary Volume 2, page 562, paragraph 14. And just to pick up a point which arose this morning, what you do is you submit the receipts as they arise. You don't wait to the end of the assessment period and submit everything in one go.
Interesting that the corroboration she was asked to provide was not a bank statement showing the money flowing out of her account, but the invoice from the childcare provider.
Quite. There is no check to see if the childcare which has been paid by way of the childcare element, is used during working hours. So just to give you an example, if you work 10 hours a week and claim the childcare element for 10 hours a week, but suppose you have grandma available to look after the child for 2 of those working hours, you could use 2 of the hours of paid childcare to go to the cinema, and there's nothing in the system to detect that. If you want a reference for that, it's the same passage that I gave you the reference for just now. It's the following 2 paragraphs. So it's paragraphs 14 to 16 of that passage. Now, in either case, in the existing proof of payment rule or in a proof of liability rule, there is no reason why spot checks couldn't be made.
Other than human resources.
Yes, but they're not made at the moment. Presumably they wouldn't be made in respect of a proof of liability rule, but in either case, if the resources were available or was a particular concern, it could be done. The 5th point is to deal with the question that was raised by the court yesterday. If you pay for childcare up front, your child then is ill on certain days and you can't use the childcare that's been paid for, and the contractual arrangements with the childcare provider give no right to a refund, are you required to deduct that from your universal credit claim or possibly repay the Secretary of State? And before, I'm going to look at the language of the regulations to answer the point, the passage that my lady referred to. But before I do that, could I just ask you to stand back and consider the consequences of a construction which prohibited recovery of that form of childcare? It would mean that the parent has, acting perfectly properly and in good faith, incurred costs of childcare which can't be recovered from the childcare provider. And unless that is recoverable through the childcare element, then the parent will, through no fault of their own, suffer a loss. And in fact, it's likely to be a double whammy, because the parent will presumably have to take the day off work to look after the sick child. And if you're on a 0 hours contract, that'll be a day's lost income. So such an approach, if it's the true construction of the regulations, would introduce a significant financial risk for parents and would be a disincentive to using universal credit to put children into childcare in order to increase working hours. I've put it no higher than this, but that would tend to undermine the purpose of universal credit, one of the purposes of universal credit. And so, in my submission, the court shouldn't lightly construe the regulations to have that effect.
Yeah, I speak for myself. I wasn't suggesting it was desirable. I just wanted to know how it worked.
No, but of course, one takes a purposive approach to construction. The modern approach is to take a purposive construction, obviously looking at the language as a guide. But I just wanted to say that before I look at the language of the regulations. And it's in the regulations binder at page 78. So it's Regulation 35 of the Universal Credit Regulations 2013. This was the passage identified by my lady. And if we begin with the heading of the regulation, it's headed Meaning of Relevant Childcare. And in my submission, the function of this regulation is to identify who can provide relevant childcare. And the answer that one sees, looking through the whole of the regulation, is that it has to be a regulated provider. So the overarching purpose of this regulation in our submission is that it's about who can provide rather than whether it's being provided. Of course, that doesn't mean that it might not have other effects, but that's the work that this regulation is doing. So then we look at Regulation 35(2), care provided in England for a child. Now, if that were to be read as indicating that the childcare must in fact have been provided to the child so that the parent has to bear the cost of childcare if the child is sick, then that undesirable result would have been achieved in a most indirect way. And in my submission, if one takes a purposive approach to the construction of this regulation, that cannot properly be read as the purpose of it.
Sorry, I haven't quite worked out how 35(2) works.
But I think the point that
Care, just to help me with this. Care provided in England for a child.
Well, could we go back a step? It may help, my lord, if we could go back a step, look at paragraph 1. Relevant childcare means. And so that imports the meaning in regulation 35
into
33
yes,
of
I've got that. Yep.
And then relevant childcare means, as set out in 2.5, to care provided.
You've got to have paid charges for relevant childcare.
Yes.
So,
Yes.
and you say paying charges for relevant childcare means paying charges for childcare which is provided by basically a regulated provider of one of these particular types,
yes,
rather than childcare actually provided in the instance of the individual case.
Exactly so. That's the submission. Now, it may thought not to be desirable in the context of this case to determine that to construction, but I wanted to deal with the point. Sixth, can I deal with the... Sorry, my lord.
No, to put it the other way around, what you are entitled to payment for as the childcare element is, under the present arrangements, what you have paid for, or under the arrangements you say could be made, what you would be liable for, irrespective of whether actually taken up.
Yes, you've got to be, on a proof of liability approach, one does genuinely have to be liable.
Yes. But depending on your arrangements with the provider, you might not be liable if they didn't charge you unless the child appeared. But more commonly, I suspect, once you were committed, you'd be liable to them anyway.
Exactly.
But
exactly.
And I can see the sense of that construction, because if you look at the exclusion in subparagraph 7 of paragraph 35, it means you rule out care provided by grandma or auntie or somebody else within the family.
Exactly. So that's in my submission is the work that this regulation is doing. The payment at the moment, as the regulations work, the payments have to be to a regulated child care provider, and that gives the state assurance that it's being done in a properly formal way rather than money being siphoned off to friends and family.
Mm-hmm.
I'm being dense, I think, but on the liability scheme, if we try and map that onto these regulations, are you going to tell us how it works so far as Regulation 34A is concerned?
Well,
I don't want to take that out.
I wasn't
if you're
going
to come to it.
No, I wasn't going to.
Right.
Can I deal with it now?
Yeah.
Which is that one begins at page 73 with Regulation 33. And so the childcare costs condition is met if the claimant has paid charges. Now, ex hypothesi, that provision is going to change.
Yeah, so you say has a liability, has incurred a liability.
Then we go to 34A, which is page 76. That is all about charges paid for relevant childcare.
Yes.
So the whole of 34 would have to be remodelled
Yes.
if one introduces a proof of liability provision into 33. Now, precisely how it's to be remodelled, if that's what's to be done, is a matter for the Secretary of State.
Yes, but what I'm trying to get at, and this is where I may be being dense, is whether remodelling that would inevitably, or at least very likely, create the kind of problem that we were debating yesterday, where if the childcare is not provided, the liability having been incurred, you get back to that problem. The person gets paid for childcare that's not provided. And let's suppose it's not an illness, it's just the person's working arrangements change, and in good faith they put in the liability, they put in the bill for childcare to be provided during the assessment period, and it doesn't get provided because they've opted out of it. Either they're able to avoid the liability because those are the terms on which it's been the contract provides the service, or they're not. There has to be some reconciliation.
Just as there must have to be in respect to the housing element. So suppose that you accrue a liability to the accommodation provider, and on that footing you can claim the housing element through universal credit. But you don't discharge the liability. And suppose you come to an arrangement with the provider that month they're going to let you off 20% of the rent because you've got cash flow problems. There would need to be a reckoning. There would need to be an account to the Secretary of State for that shortfall, notwithstanding that the liability had accrued.
Yeah, but then it does. If we just focus on the childcare element, this approach would tend to create a greater need for interaction between I think they call them the customer, don't they? Anyway, an interaction between the state and the individual than the so-called proof of payment method.
Well, can I come to that in just one moment? Just to finish off my point about the comparison with the housing element. It would create no greater need for interaction than must exist in the housing element. That was the point I was making. To address my Lord's point, would it create a greater need for interaction than the proof of payment rule in respect to childcare? Well, suppose that, as I explained earlier, what one does is one submits a proof of payment of receipts at the point that the receipt's given. And if later the childcare isn't taken up, let's say, and the terms of the arrangement are such that the parent is entitled to a refund of those days, then on that basis too, there needs to be an account to the Secretary of State.
But not you submit if they aren't entitled to a refund.
But not if they're not entitled to a refund. But in answer to my Lord's question, the same kind of need for reconciliation arises on either approach.
Yeah.
Thank you.
So my sixth point is then to deal with the pleadings question that my Lord the Vice President identified yesterday. And I think the question is, was the proof of liability issue sufficiently flagged? And could I ask you, you were shown one passage of the Statement of Facts and Grounds by my learned friend. Could I just show you one more passage, which is in the core bundle at page 100, so it's tab 10, page 153. And one sees at paragraph 2 of the Statement of Facts and Grounds, the effect of this, the proof of payment rule, is to require eligible parents to self-fund the cost of childcare and claim it back through the Universal Credit Award. This disadvantages parents who lack the funds to pay the upfront cost of childcare. It stands in stark contrast to the way in which other components of universal credit are paid, for example, the housing cost element. And it was no doubt in light of that Ms. Parker, in her witness statement, expressly dealt with the housing cost element. That was the passage that my learned friend showed you this morning. If you'll notice, paragraph 82 of Ms. Parker's statement, supplementary 2, page 628.
So which paragraph?
Paragraph 82.
Thank you.
It was also raised even more prominently than in the statement of facts and grounds in the skeleton argument in the High Court. It was front and centre of the skeleton argument. And you've got the skeleton argument, if you want to see it, at supplementary volume 3, page 1311. At paragraph 4. Now, this pleadings issue was discussed with the judge below. It's not recorded in the judgment, but it was discussed at the hearing. And no application was made by the Secretary of State to exclude this point or to seek an adjournment to give the Secretary of State more opportunity to put in evidence in response to it. And I would just observe that it's no part, of course, of the Secretary of State's appeal that she didn't have a fair opportunity to address the proof of liability rule in her evidence. Seventh point is that in my submission, the judge was right to point out that housing costs may fluctuate just as childcare costs may fluctuate. And if I could ask you, please, to look again at his judgment.
This is the point about service charges.
Exactly. But also, actually, the accommodation costs themselves. So it's page 95 of the judgment. Paragraphs 19 and 20. So paragraph 19, the judge refers to regulation 25.2a and all of the kinds of things that can constitute payments in respect of accommodation. And in paragraph 20, he deals with service charge payments. And so, for example, the housing element would cover site costs for a caravan. I can take you to the regulations if you want to see it on the face of the regulations. And so one can see that the site costs for a caravan might increase during holiday periods when demand for pitches rises. And it also covers service charges, as we've seen, which might increase in the winter months when the landlord has to heat communal areas or replace tiles on the roof. And then the judge's conclusions on this, page 141. This is part of paragraph 173 at letter J. Third line, whilst it may be true that there's less variation in housing costs than in childcare costs, an analysis of the UC regulation shows that the housing element covers costs such as service charges, which may well fluctuate. And then last four lines of that subparagraph, there is nothing in Ms. Parker's statement which explains why such a system would be any less able to deal with a fluctuating cost of childcare than the current system where entitlements based on proof of payment. And there is no a priori reason to suppose that it is.
But there are, I mean, intuitively, there are obvious differences between childcare and accommodation in terms of the likelihood of fluctuation and in terms of the link with the objective which you place at the forefront of your argument. If the primary or a main objective is to make work pay, and that's the purpose of including childcare as an element of the universal credit, that's a completely different relationship with that element of the credit than from the link between accommodation. I mean, everyone's got to have accommodation of some kind, or at least those who are claiming universal credit will have
Well, that is true. Of course, I accept there's a distinction between housing because housing fulfills a more basic need
and it's continuous.
than the need to work. I accept that. But of course, if one could take a completely utilitarian approach and regard humans as units of production, and in that respect, they need accommodation to work in the same ways as housing. But I do accept the point.
So there is that. Pressing the point a bit further, one could say that there's an obvious rational basis for distinguishing between the two. If the comparison is between the approach to the two benefits, it would remain the case that the judge made the point that there's no specific explanation in the evidence of why such differences as do exist mean that the same system can't be applied to the two different elements. That doesn't. My observation doesn't undermine that point.
There are distinguishing the function of the housing element is distinct from the function of the childcare cost element. Of course, that's right. The question that the judge was addressing was whether there was any proportionate basis for not applying the same rule, the liability rule, in the context of childcare. And the point that the judge arrives at letter J is that there's nothing about the nature of housing costs in contrast to childcare costs which makes the liability rule any less appropriate in the childcare context. My eighth and final point under this broad heading is just to pick up just a few words in the Secretary of State's post-hearing note from the hearing below, which was handed up this morning.
Just give me a moment. Yes.
And if you would please look at paragraph 9. This is under the heading analysis. And what's said at paragraph 9 is that second sentence, housing is treated differently insofar as there's no requirement to demonstrate that liability has been discharged before receiving the UC payment. Well, that's obviously agreed, but that doesn't alter the fundamental position that the housing is paid in arrears. Again, that's agreed. But then the words in brackets, and upon the housing having been provided, that's not agreed. Because there's nothing we say in the regulations which says the housing has to be provided before you can recover in respect of the liability for housing. I don't think it really goes anywhere, but I just wanted to lay down a marker that we don't agree those words.
So, hard to see a situation in which it would arise in
Well, what it means,
practice.
can I give you a practical example? What it means is that if you incur liability for housing costs in January, in respect of accommodation to be occupied in February, this is a typical example, the lease provides you have to pay a month's rent in advance. At the end, in respect of that January assessment period, you can claim for the liability that's accrued in January in respect of the accommodation that's to be provided in February, even though the accommodation hasn't yet been provided in February.
Yes, I
And can I just, I don't think that anything turns on this, but can I just show you the regulations to show you why we say that? It's in the regulations bundle at page 59.
So, what do you mean by the regulations bundle?
So I've got the 2013 regulations in a separate bundle. It was the bundle that was handed up by my friend.
Of course, I'm so sorry. Yeah.
And so page 59 is regulation 25, the housing cost elements.
Yeah.
Paragraph 1, we see what needs to be satisfied and what needs to be satisfied in paragraph 2 to 4. Paragraph 2, the payment in respect of accommodation must be rent payments or service charge payments. Then 3, the circumstances of the liability to make the payments must be that the claimant has a liability on a commercial basis or something else as provided for by the schedule. And then 4, the circumstances in which the accommodation is occupied, and this must be what the Secretary of State is referring to, must be such that the claimant is treated under Part 1 of Schedule 3 as occupying the accommodation as their home. So that's the potential limiting factor. And if one can then turn to Schedule 3, which is at page 112, and one sees paragraph 1 of Schedule 3, subparagraph 1. The general rule is that a claimant is to be treated as occupying as their home the accommodation which the claimant normally occupies as their home. And then there are a series of special rules which follow relating to croftland, etc. But that's the general rule. And that, we say, places no limitation of the kind that's referred to in the Secretary of State's note. It's just got to be your home.
See, there's a special rule in relation to moving out to have essential repairs carried out as well.
Yes. But unless there's anything further that arises from that was the end of my second topic, and I'm sorry it was a slight scattershot of points.
No, very helpful.
So the third broad topic is how do you test for indirect discrimination? And I understand it to be common ground that the inverted commas test for indirect discrimination under Article 14 is simply that a measure has a disproportionately prejudicial effect on a particular group. And that was identified, that's correctly identified by the judge, paragraph 147 of his judgment. I'd just ask you to note that Strasbourg hasn't applied the more elaborate formulation for indirect discrimination that we have in Section 19 of the Equality Act. I wasn't proposing to turn it up, but it's one of the documents in the bundle that I handed up. So could I please begin with the judge's first formulation, the more controversial one, that universal credit claimants claiming the housing element are excused having to show proof of payment, but universal credit claimants claiming the childcare element aren't, and that many more women than men are therefore required to prove payment in order to obtain universal credit. Now, the Secretary of State says, as I understand it, that it's only ever permissible to compare the proportion of women who are required to satisfy the rule with the proportion of men who are required to satisfy the rule. That, I think, is the case that's put against me. And so she says, she, the Secretary of State, says that within the cohort of persons eligible for the childcare element, all women and all men are required to satisfy the proof of payment rule, and accordingly there's no differential effect. And can I make 5 points in response to that case? The first point is that Strasbourg takes a much less strict approach to comparators than, for example, the Equality Act, which implemented EU law. And on this point, can I please ask you to look at the additional bundle I handed up earlier? And if you please turn to tab 2. And just to note that at page 2, we've got section 13 of the Equality Act, which is direct discrimination. Page 3, we've got section 19 of the Equality Act, which is indirect discrimination. And then page 4, we've got section 23, which deals with comparators. And what one sees is that a very particular approach is taken to comparators in relation to both direct and indirect discrimination under the Equality Act. 23 subsection 1, on a comparison of cases for the purposes of section 13, direct, or 19, indirect, there must be no material difference between the circumstances relating to each case. What I wanted to do was to show you the different approach that Strasbourg takes. And if you could please look at the first volume of authorities. Tab 7. You should have the judgment of the House of Lords in AL Serbia. Now, this was a challenge to a policy which allowed asylum seekers with families to obtain indefinite leave to remain. And the claim was that this discriminated against single young adults. And it was a claim of Article 14, direct discrimination. If you please look at page 171. Could I please ask you to read paragraphs 24 and 25? And so the essence of it, the bottom of page 171, this suggests that unless there are very obvious relevant differences between the two situations, it's best to concentrate on the reason for the difference in treatment and whether they're justified.
But the difference in treatment has to be on a prohibited ground. And so if you're comparing the group of people who, within universal credit, who have housing benefit, with the group of people who have childcare, they're not being required to pay up front because they are women.
I'm going to, if I may, take it in stages. All I wanted to show, the reason I'm showing you this, is to show that Strasbourg takes a much broader approach to comparators than one does under domestic or EU law. Yeah. And one can see that because the approach to, albeit this is direct discrimination, it's a fundamentally different approach to comparators than the one mandated by sections 13 and 23 of the Equality Act.
I'm not sure how fundamental the difference is.
The analogy has to be close enough. It doesn't have to be an exact comparator, but it has to be an analogous comparator. So you're still looking to see whether or not you've got two people in comparable situations, or where you can actually find a measure of similarity between the situations that those two people are facing.
I absolutely accept
And
that.
under section 23(1), he only talks about material circumstances, so that in fact there's quite an area of judgment. I'm not convinced there's really any real difference here.
Well, very well, but so long as one is content to apply the breadth of approach that is described in these passages of the Bail Circuit, and there's certainly no quarrel from us. Now, I think I've got time to do my second point, which is that in the case of Detrizio, which you were shown yesterday, we say that the Strasbourg court undertook a similar analysis to the first of the judges' two approaches. Just to recall that the judges' approach, the comparison of the proportion of women in the childcare group to whom one rule applies, with the proportion of women in the housing group to whom a different rule applies. That is my submission, what the Strasbourg court is doing in Detrizio, and I just want to make that good by taking you through the authority, if I may. It's volume 2 of the authorities. Tab 35. So it's a decision of the second section dated the 2nd of February 2016. And what the Swiss authorities had done was to apply a different method of calculating disability benefit, depending on whether hypothetically you were a full-time worker or a part-time worker or a non-worker. If you were hypothetically a part-time worker...
So when you say hypothetically, what do you mean?
Well, you weren't actually working because you were disabled.
I see what you would have been, yes.
What you would have been doing.
Yeah.
Then if you're hypothetically a part-time worker, then a different method applies, what was called the combined method. Now, using the combined method, the applicant wasn't entitled to disability benefit. But had the method that was applicable to full-time workers or to non-workers been applied to her, then she would have been entitled to disability benefit. Can I show you that at page 1226? Paragraph 49, this is the passage you were shown by my learned friend. The applicant contended that she was placed at a disadvantage, first of all compared with individuals who didn't perform any paid work, so the non-worker group. In a case like hers, such persons would be considered to have a 44% disability and would therefore be entitled to a benefit, the threshold being 40%. She was also discriminated against compared with individuals who didn't have to take care of a household or children and who could therefore work full-time. In a situation identical to hers, such persons would be deemed to have a 55% disability. so different methods apply to different groups. And then if one looks over the page 1227, the top of that page, Roman 2, the applicant contended that this was indirectly discriminatory on the grounds of gender.
But they were all different groups of claiming the same benefit.
Just as these are different groups claiming universal credit. The question will be comparability, and I'll come to that. And then below that, we see the heading Applicability of Article 14. And immediately below that, there's a heading ambit. Just while we're here, wasn't proposing to say very much about ambit later. Could I ask you to note what the court said about ambit at page 12?
So, I've lost, where's the heading ambit?
Heading ambit is on page 1227. There's a heading merits, and below that, applicability of Article 14, and below that, whether the
yes, the heading is whether it falls on.
Sorry,
I was looking for something else. Yep, got it.
And then turning the page to 1229. Could I just ask you to note paragraphs 61 and 62 in relation to ambit?
Actually, the converse of this, isn't it?
Yes, exactly.
This
is
is the
enabling
measure
her
which
to
enables.
go out.
Yeah.
But the rule being applied by the Strasbourg court is whether, the test being applied by the Strasbourg court is whether the rule in issue is apt to influence the way in which family life is organised.
Yes.
But that's, I'm afraid, a digression from the point I'm seeking to make. Returning to the nature of the indirect discrimination, could you please look at page 1230? Paragraph 66. It's clear from these observations, and in particular from the statistical data furnished by the parties, that in the overwhelming statistical data is going to come later. It's not a very well organised judgment. But in the overwhelming majority of cases, the combined method concerns women who wish to reduce the amount of time they spend in paid work following the birth of a child or children. Accordingly, the court considers that the applicant is entitled to claim that she's been a victim of discrimination on the grounds of sex within the meaning of Article 14. And then paragraph 68, under the heading conclusion, it follows that Article 14, taken in conjunction with Article 8, is applicable in the present case. Then below that, there's a heading compliance with Article 14. And if you would please turn forward to page 1233. We get the court's assessment and summary of the relevant principles. And then paragraph 80, the last 6 lines recites the well-established test. The court has also accepted that a general policy or measure that has disproportionately prejudicial effects on a particular group may be considered discriminatory, even where it's not specifically aimed at that group, and that discrimination potentially contrary to the convention may result from a de facto situation. And then overleaf, page 1234, there's a heading a third of the way down, proof as regards discrimination. And if you could please look at paragraph 84, the 7th line reads, as far as allegations of indirect discrimination are concerned, the applicant must adduce evidence of disproportionately harmful effects on a particular group, giving rise to a presumption of indirect discrimination. It's then for the respondent's state to rebut that presumption by showing that the difference in treatment was the result of objective factors unrelated to the factor identified by the applicant. And then could I ask you please to read paragraphs 85 and 86. We then get the heading application of the above mentioned principles to the present case. Below that, the subheading existence of a presumption of indirect discrimination in the present case. And what one sees in paragraph 88, if I just paraphrase it, is that 97% of the part-time worker group to whom the combined method applied were women, but 3% were men. And then paragraph 90, that's enough from which to presume indirect discrimination. And then finally, if we look at the court's approach to justification on page 1237, paragraph 100 is divided into two parts. The second part reads, in the court's view, these are clear indications of a growing awareness of the fact that the combined method is no longer consistent with efforts to achieve gender equality in contemporary society, in which women increasingly legitimately seek to reconcile family life and career. And then on page 1238, the first, up to the end of the first paragraph, moreover, end of the first line, moreover, the court observes that several methods of calculating disability exist under Swiss law. Accordingly, the court notes that alternative calculation methods are possible, which would take greater account of women's choice to work part-time following the birth of a child, thus enabling the aim of greater gender equality to be pursued without jeopardising the objective of disability insurance. Now, I wonder whether I was going to then turn to my observations and what conclusions one can draw from this judgment, but I think I may need to wait until 2 o'clock to do
Yes, very well. How do you think you're doing?
I'm afraid I don't think we're going to finish today.
No, I'm afraid that's likely how it's turned out. I think if perhaps contrary to expectation, it would make the difference for us to sit a bit late, we will do so. But if it won't, we won't.
Thank you.
Thank you. 2 o'clock.
All right.